Yes, Mr. Mehta. Yes, it's done.
21 of the compilation of the governor, my lords.
Right.
Lord, please, Lord, note one difference. It's not legislative party members showing lack of confidence in their party. It's not their internal party affairs anymore. These members are saying that we are withdrawing support from the government. My lord, that's the distinction. And my lord, I would hasten to add, my lord, that this not being, my lord, a petition or a suit may not have a prayer clause, etc. But governor, my lord, as I will show from one para of Bomai, from whatever material, if he comes to the prima facie satisfaction, and that test is accepted by my lords, my lord, in the Shivraj Singh Chauhan judgment, that there is loss of confidence by this government, then he can ask, not only can ask, he should ask the floor test. My lord, kindly see para 2, my lord, once again. As is common knowledge, we no longer wanted to be a part of corrupt MVA government. However, we are being continuously threatened to continue supporting the incumbent government without our free will, thus left with no option, etc., my lord. And this is signed by 47 members of the Legislative Assembly, not just Shiv Sena MLAs, but independents and 2 members of Prahar Jan Shakti Party saying we are withdrawing support from the government. And oh my. This is, my lord, in my respectful submission, the material as
Para 2 my first sentence.
my apologies. My lord, page 21 of my apologies.
Only it is the common knowledge that we no longer
Lord, govern
wanted. It's impossible. Wanted to be part.
No, it's past and continuous also. That we have already declared that we don't want to support. But now we are being pressurized to support. That's what. Lord, kindly see. And I'll show Lord para 393 Bomai. Lord, from whatever material he comes to a prima facie conclusion that there needs to be a floor test, Lord, he would be under an obligation. We don't want to support this government and therefore give us security because we are being threatened. Second, Lord, what is the fact situation before the governor? And I'll read only one para from Bomai. One set of MLAs, namely 47, saying that we want to withdraw support from the government. One set of MLAs, my lord, or the leaders of the party saying that we will see when you come on the floor of the house. In my respectful submission, I'm posing a question to myself. Would the governor not be justified in forming an opinion that the government has lost confidence? I'm not saying anything. I'm not preempting anything. As Mr. Sorabji narrated several possibilities, I'm only asking for the floor test. Maybe they might change their view. Maybe they might sacrifice themselves. Maybe they stand disqualified. Maybe they are persuaded. Maybe the leadership changes. There are several possibilities. The governor, my lord, in my respectful submission, my lord, will have no jurisdiction once he has a material. And what can be the material? Apropos her ladyship's question, my lord, page 393, para 393 of SR Bomai, my lords. It need not be a letter also. Well, suppose in a given set of circumstances, it's in public media, everywhere, which cannot be disputed. All channels are showing something. Lord, I'm posing a question to myself, Lord, can the governor not examine those facts also? But ultimately, he is not just, my Lord, when a 174, 175 situation arise, he is not supposed to be a mute spectator. He will have to act. His action would be subject to judicial review. Within, my Lord, the parameters which your Lordships have fixed, my Lord, for my Lord's, my Lord, future assistance. But please see, my Lord, 393, which is at, my Lord, volume, judgment compilation, volume 2, PDF 518. Lord, that's Bomai judgment, my Lord. Am I with your Lordships, my Lord? My Lord Justice.
And Lok Prahari and these 17 independent MLAs were backing the government up to then.
Yeah, yes. Seven, my Lord.
Seven.
Seven. And, my Lord, one set of 393. In this connection, it would be appropriate to notice the unanimous report of the Committee of Governors appointed by the President of India. The 5 governors unanimously recommended that the test of confidence in the ministry should normally be left to a vote in the assembly, where the governor is satisfied by whatever process or means. Please kindly see, my Lord. It need not be a prayer that please hold a floor test, etc., my Lord. People are telling him that the government is not enjoying our support. They've lost the confidence. By whatever process or means that the ministry no longer enjoys majority support, he should ask the chief minister to face the assembly and prove his majority within the shortest possible time. If the chief minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A chief minister's refusal to test his strength on the floor of the assembly can well be interpreted as prima facie proof of he is no longer enjoying the confidence of the legislature. I'm sorry, your lordships. Lord, the subsequent event of the Honorable Chief Minister not deciding, deciding not to face, my Lord, justifies the decision that whatever material I gathered and the satisfaction I arrived at was a right satisfaction, that the government has lost the majority confidence. Now, my lords, may allow me to place, my lord, the Shivraj Singh Chauhan judgment, my lord. My lord, and that, my lord, I would earnestly request your lordships, my lord, to permit me to read, because that was read by the petitioner, bits and pieces on, my lord, this side, but not from the governor's point of view, my lord. I'm sorry, my lord, page 395, my learned friend is right. My lord. Para 395 also in Bomai, my lord. 395. Because it's not a luxury which is, my lord, conferred upon the governor. My lord, it's a duty.
392 or
395, my lords, of SR Bomai.
And what is the PDF page? Can you give me?
518, my lord, judgment compilation 1. 2, I'm sorry.
5-1.
518, my lords. 395. The High Court, in our opinion, erred in holding that the floor test is not obligatory, if only one keeps in mind the democratic principles underlying the Constitution and the fact that it is the Legislative Assembly that represents the will of the people and not the governor. The position would be clear beyond any doubt. In this case, it may be remembered that the Council of Ministers not only decided on so-and-so to convene the Assembly on so-and-so, but also offered to prepone the Assembly if the governor so desired. It pains us to note, Lord, your Lordship, that's on the facts of the case, my Lord. A governor did not choose to act upon the said offer, and my Lord, that was frowned upon by the court. Indeed, it was his duty to summon the assembly and call upon the chief minister to establish that he enjoyed the confidence of the House. Not only did he not do it, but when the Council of Ministers offered to do the same, he demurred and chose instead to submit the report to the President. Lord, here I am being asked by the person who did not choose to face the vote of no confidence, that why did you call for the vote of confidence? Why did you call for the floor test? The converse situation and more drastic, my lord, in terms of the facts. In the circumstances, it cannot be said that the governor's report contained or was based upon relevant material. There could be no question of the governor making an assessment of his own. The loss of confidence of the House was an objective fact which could have been demonstrated one way or the other on the floor of the House. In our opinion, wherever a doubt arises whether the Council of Ministers has lost the confidence of the House, the only way of testing it is on the floor of the House, except in an extraordinary situation where, because of all pervasive violence, the governor comes to the conclusion and records the same in his report that for the reasons mentioned by him, a free vote is not possible in the House. So, my lord, it's not his right, it's his obligation. Now, my lord, kindly come to, my lord, my lord, the threshold in my respectful submission is that some material which creates a doubt in his mind. And, my lord, I would, my lord, at the cost of repetition and with profound respect, my lord, please, this is a constitutional submission. Don't, my lord, misunderstand the submission. My lord, the threshold of your lordship's judicial review, which I am not disputing, would be whether there was any material, whether based upon that material, your lordships may perhaps would have taken a different view, may not be a test. Now, your lordships, my lord, kindly come to Shivraj Singh Chauhan, my lord. Volume 1, 1360, my lord, PDF 1360. Lord, I want your lordships to, my lord, see the contentions raised. Because that was not read before your lordships, my lord. And this would really be, my lord, illuminating and will assist your lordships to lay down the law correctly.
1360.
Yes, my lord. 1360 PDF. It is internal page 22 of Shivraj Singh Chauhan. Lord, this is the arguments of Dr. Singhvi, which my lords were pleased to, my lord, record. 17.2. My lord, I have marked my copy so that I don't have to, my lord, read everything. And your lord, I leave, my lord, something which is not relevant. Your lordships can trust my discretion on that, my lord. 17.2. There is a fallacy in the assumption that the governor has any locus to direct the chief minister to conduct a floor test to establish a majority on the floor of the House. Next, this court ought not to enforce the direction for convening a floor test, as it will have the effect of short-circuiting, as it was described, the large discretion which is entrusted to the Speaker on the matters of resignation by members under Article 190. Then, my lord, 17.8. The precedent of this court in regard to convening of the trust vote have arisen in the context of fresh elections held to the legislature and not in the context of a running assembly. My lord, Shivraj Singh Chauhan was a case of a running assembly, and in the midst of the, my lord, the government functioning, the then chief minister lost the confidence. This is what your lordships were dealing with, my lord. Now, my lord, kindly come to para 19. Again, my lord, submission. Elucidating on the above submissions, it was urged that the object of exercise undertaken by the so-and-so is to find a way around the 2/3 stipulation contained in the 10th schedule by engineering resignations of the 22 members in a running house. The submission is that if a trust vote were to be held before a decision has been taken by the Speaker on whether to accept the resignation of the members, this will pave the way for the 16 members whose resignations have not been accepted till date to abstain from voting. Their abstention, it has been urged, would alter the strength of the members present and voting, thus modifying the required majority in the House and impacting the outcome of the trust vote. Now, your lordships, my lord, kindly directly go to para 26, my learned senior Mr. Sibbal's submission. Lord, it would be at PDF page 1363. 1363. Mr. Sibbal contends that the observations of the Constitution bench in Nabam Rebia on the authority of governor to order a trust vote to be conducted on the floor of an ongoing legislative assembly are purely omitted. But Nabam Rebia was also an ongoing assembly, not first time government formation. The case before the Constitution bench in Nabam Rebia dealt with a situation where the governor had preponed the date for meeting of the legislature assembly to decide the question of speaker's removal. It was submitted that Nabam Rebia is not a precedent for the proposition that the governor is entitled to require a trust vote to be conducted on the floor of a legislative assembly, which has been duly constituted and is in session. Mr. Sibal submitted that the consequences of upholding the power of governor would be to encourage both the demolition of an elected government and the democratic structures of the governance. Mr. Sibal's submission, governor would have the power to summon the House where it is not in session. Since under Article 168, the governor is a part of the legislature, if the House is not in session, it is open to a governor to seek a special session where facts indicate that the existing government has lost its majority. But this is in support of what I did as a governor. That if it's not in session and something would turn on his written another argument that no confidence motion was the only way and not the confidence vote by floor test. However, in a similar vein, Dr. Singhvi's submission, Mr. Sibal urged that this course of action is not open to the governor when the House is in session, and in such an eventuality, the only remedy is to seek a motion of no confidence to test whether the incumbent government is possessed of the confidence of the House. With respect to exercise of the power of the governor by calling for a trust vote, it has been submitted by Mr. Sibal that there must exist an objective satisfaction of the governor based on material in his possession. Absent a physical verification, it cannot be said that mere tendering of resignation by members led to valid exercise of power by the governor to call for a trust vote. Here, my lord, withdrawing support from the government. In the present case, the governor had no material to conclude that 16 members had submitted their resignations voluntarily. Legislative history in the country indicates that minority governments have survived, and unless it is shown that mere tendering of resignations actually caused the loss of confidence in the incumbent government, it is not open to the governor to conclude that actions of the 16 members would result in a loss of confidence. Here, they specifically say in writing that we want to withdraw support from the government. My lord, your lordship, my lord, kindly, my lord, then skip my submissions, my lord. I happen to appear for the governor there, my lord. Kindly, my lord, come to 1369, PDF 1369. Para 42.
ये page?
1369, my lord. 1369. The governor relied upon, my lord, this. Para 42, my lords have. My Lord Justice Narasimha. The letter sent by the governor to the chief minister indicate that the governor relied on the following circumstances in coming to the conclusion that a floor test was urgently required. The receipt of information by the governor that 22 members who had previously supported the incumbent government had submitted their resignations to the Speaker of the Assembly. The members who had tendered their resignations had communicated their decision through the print and electronic media. Copies of the letters of resignation had been submitted by the 22 members to the governor. The 22 members had asked the governor to provide security to facilitate their appearing before the Speaker. Amongst the group of 22 members who had tendered resignations were 6 cabinet ministers whose resignations had been accepted by the Speaker. Now, my lord, may kindly come to 43. It was on the basis of the above material and circumstances that the governor informed the chief minister of his having formed the opinion prima facie that the government had been reduced to a minority in the House, making it necessary to conduct a floor test immediately after the address of the governor at the budget session. Then, my lord, para 44, the action of the governor requiring a trust vote be carried out has essentially been assailed on 3 broad grounds of challenge. It has been submitted that governor had no power to order a trust vote in course of an ongoing legislative assembly or at any rate while the legislative assembly was in session. If the governor did possess such a power, then the exercise of the power by the governor in ordering a trust vote impinged upon the authority entrusted to the Speaker under proviso to Article 190, Subarticle 3B. And 3, the governor had no objective basis or material to form the prima facie opinion that incumbent government had lost its majority in the Madhya Pradesh Legislative Assembly. Now, my lord, questions before the court, my lord, kindly come to PDF 1371, para 46. The present controversy raises two separate but intertwined constitutional questions. First, whether the governor is entrusted with the authority to call for a trust vote in the course of a running assembly. And second, whether the governor exercised this authority correctly. If the governor does not possess the authority, the action of calling for an immediate floor test is ultra-vires and unconstitutional. Alternatively, if the governor does possess the authority to call for a floor test, this court must determine the contours of such power and answer the question of whether the governor acted within these contours. It was briefly contended before us that this court should be wary of entering the realm of politics where no judicially manageable your lordships can skip that. Lord, kindly come to page 1372, para 50. Constitutional role of the governor. But I don't think, my lord, anything more is required to be said by me, except, my lord, very respectfully adopting my lord's judicial determination. Para 50, your lordship, my lord. Can I read?
Yes.
Para 50. We must consider the constitutional scheme in operation between the state legislature and the office of the governor. As a matter of constitutional principle, the state legislature comprised of the governor and the legislative assembly. The governor is not an elected member of the state legislature. The governor is appointed by the president and is the head of the executive branch in whom, under Article 154, the executive power of the state is vested. While holding office at the pleasure of the president, the governor as a constitutional authority, is not a member of either House of Parliament or the legislature of the state. Thereafter, my lords were pleased to trace the history, which, my lord, with my lord's permission, I may skip, my lord, at this stage. My lord, may not be necessary how the governor as a constitutional head came into being. My lord, please come to page 1375, para 757. The Constituent Assembly thus decided to vest the office of the governor with certain discretionary powers under the Constitution. In taking this decision, the Constituent Assembly was aware that there were certain associated risks in granting the governor discretionary powers, including in question of formation, disruption, and dissolution of democratically elected governments. However, the framers felt that this discretion was necessitated by unique historical factors that existed at the time of adopting the Constitution, and it was hoped that with the maturing of our polity, a level of constitutional statesmanship and trust would paper over the cracks of constitutional choices necessitated by more violent times. My lord, kindly come to, my lord, para 61 at PDF page 1377. Lord, all arguments which are made here were advanced, were present before your lordships, and my lords were thereafter, my lord, pleased to lay down the law. Para 61. The issue of whether a governor can call for a trust vote in an already constituted legislative assembly is not entirely res integra. Before a 9-judge bench of this court in S.R. Bomai, the individual cases which came up for consideration included the dispute emanating from the state of Karnataka. In the state of Karnataka, following elections to the assembly in March 85, the Janata Legislature Party emerged with the majority. Sri Hegde was elected as the leader of the house. Lord, kindly allow me to read these facts. Lord, there is something, Lord, which may assist your lordships. Sri Hegde was elected as the leader of the party and was sworn in as chief minister. Following his resignation, Sri Bomai was elected as the leader of the party and was sworn in as chief minister on so-and-so. In September, there was a merger of Janata Party with Lok Dal B, resulting in formation of Janata Dal. On so-and-so, a legislator defected from the party and presented a letter to the governor of Karnataka withdrawing his support from the Janata Dal government. The legislator met the governor on the next day and presented 19 letters purportedly of 17 Janata Dal legislators, an independent and a BJP legislator withdrawing support from the Janata Dal government. On so-and-so, the governor sent a report to the president opining that as a result of withdrawal of support, the ruling party had been reduced to the minority in Karnataka Legislative Assembly and recommended that action be initiated under Article 356 of the Constitution. Because if this is the correct assessment of the governor, there are two options: either go for a floor test or 356, which your lordships have frowned upon. Subsequently, on so-and-so, 7 legislators submitted letters to the governor complaining that their signature had been obtained by misrepresentation and reaffirmed their support to Sri Bomai's government. The state cabinet decided to convene an assembly on so-and-so, and the chief minister met the governor, offering to prove his majority on the floor of the house, if necessary, by preponing the assembly session. In spite of this, the governor submitted another report to the president on so-and-so, and a proclamation was issued under Article 356. It was in this background that 9-judge bench, 391, I have already read, my lord. I'll skip that, my lord. Kindly come to, my lord, 65, my lord, para 65 at 1380. Where your lordships are now, my lord, analyzing Bomai's judgment in SR Bomai case. Your lordships have, my lord. In analyzing the observations made by the 9-judge bench in SR Bomai, it is pertinent to remember that the governor in that case did not call for a floor test. Rather, the governor of Karnataka sent a report to the president, based on which a proclamation was issued under Article 356. The observation in Bomai can be relied on in determining whether the governor possesses the power to call for a floor test. So this is what, my lord, I was respectfully urging. I can see both, my lord, but can't help it. Power to discerning the subsequent question of whether, when the exercise of such power is appropriate is a distant issue. On a perusal of the above observation in SR Bomai, it is evident that, your lordship's findings, whether or not the Council of Ministers has lost confidence of the House must be determined only on the floor of the House and not by the governor conducting an independent verification. Where the governor has reasons to believe, he is not supposed to pass a judgment. When he has a reason to believe that incumbent government does not possess the support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the Chief Minister to face the Assembly and to establish the majority of the incumbent government within the shortest possible time. An exception to the invariable rule of testing whether the government has the Assembly's confidence or on the floor of the House is envisaged only in extraordinary situations where, because of existence of all pervasive violence, a free vote is not possible in the House. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. Therefore, I said he should not only command the confidence, but continue to command the confidence. That's, my lord, the requirement of democratic functioning. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called in question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that governor does not decide whether incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House. That verification is not conducted by the governor. The decision in SR Bomai, in fact, held that recourse to the power under 356 was not warranted in a situation. Your Lordships can, my lord, skip the rest, my lord. Now, para 68, your Lordships were pleased to reject the argument. The argument was that the exercise of power by the governor under Article 174 and 175 should also be based on aid and advice. Your Lordships were pleased to, my lord, reject that submission. My lord, I am not, my lord, troubling your Lordship with that, my lord. Now, my lord, 69 at page 1383. Lord, judgment after judgment, it is settled, my lord. Please allow me to place Nabam Rebia, my lord, only.
Just the para 71 and 72 also.
Yes, I'm coming to that, my lord. 70 also, my lord. 70, according to I'll read 70, my lord. We are unable to accept the submission of that the observations of the Constitution bench in Nabam Rebia are obiter. The observation in Nabam Rebia are consistent with the formulation of principle in the 9-judge bench decision in SR Bomai, as we have discussed earlier. Please note, my lord, the power under Article 174 of the Constitution to summon the House and to prorogue it is one which is exercised by the governor on the aid and advice of the Council of Ministers. But in a situation where the governor has reasons to believe that the Council of Ministers headed by the Chief Minister has lost the confidence of the House, constitutional propriety requires that the issue be resolved by calling for floor test. The governor, in calling for a floor test, cannot be construed to have acted beyond the bounds of constitutional authority. And, my lord, loss of confidence mean in a running assembly. Now, my lord, your lordship may, my lord, kindly 71. The powers which are entrusted to constitutional functionaries are not beyond the pale of judicial review. Where the exercise of discretion by the governor to call for a floor test is challenged before the court, it is not immune from judicial review. The court is entitled to determine whether, in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane. These are the potent words used by your lordships. It should not be irrelevant material or something completely not germane to the issue. The exercise of such power is not intended to destabilize or displace a democratically elected government accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of satisfaction by the governor is not based on extraneous considerations. So, my lord, when there are extraneous considerations, your lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue. Issue, namely, whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my lord, perhaps your lordships may not take a second guess on the basis as to what your lordships would have perhaps perceived the situation to be capable of. Lord, kindly, Lord, para 73. Para 73, my lord.
Yes.
And I have something to say, my lord, on that no confidence, because that was not argued by any one of us, my lord. In a situation where the House has been summoned following the aid and advice of the Council of Ministers, the position would be more nuanced in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. When the government calls for the session being called, in exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures that authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent the ordinary legislative process of no confidence motion from running its due course. Lord 74. In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. Circumstances should be present before the governor. This power is granted to the governor to ensure that principle of collective responsibility is maintained at all times and must be exercised with caution. The circumstances on the basis of which the governor forms a prima facie opinion leading to a communication requiring a trust vote in the Legislative Assembly must be of an objective nature. The decision of the governor to do so is not immune from judicial review and must therefore withstand the ability of being scrutinized on the touchstone of circumstances. Again, my lordships are careful in saying being relevant, germane, and not extraneous. I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Lord, kindly, my lord, thereafter see, your lordships were pleased to, my lord, para 77 at page 1386. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test. And the only purpose was, I'm sorry, my lords are typing. I'm sorry,
Yes.
The object of my lord was, no, your lordships may complete. I'm sorry,
No.
that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. And therefore, I'm not reading, my lord, but there are large number of cases, my lord, which your lordships were pleased to reproduce. And thereafter, say at page 1389, my lord. At the para 78, at the foot of 1388. The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. Assertion of accountability is a mirror image of collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shown a light on the often fluid allegiances of democratically elected representatives. This is a matter of their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In circumstances as they have emerged in this case, the exercise of authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine that the trust vote was not the appropriate course of action on 16th March. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Lord, kindly last, my lord, para 50, para 80, my lord, at page 1390.
1 minute.
Lord, this is
1 minute.
I'm sorry. Para 79, my lord, the submission that short-circuiting the speaker's power, that governor, by asking for the floor test, has short-circuited, my lord, the speaker's power, and your lordships are, my lord, dealing with that at para 80, my lord, 80. It is trite law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the speaker has taken a decision on whether or not to accept the resignation, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers headed by the Chief Minister has the confidence of the House. The continuous existence of that confidence is crucial to the legitimacy and hence survival of the government. I could never have put it, my lord, like this. Continuous existence of that trust gives you the legitimacy in democracy. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have the faith of the legislative body as a collective entity, particularly where the members resigned in an expression of lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignations on the collective will of the House. The consequence of the acceptance of a resignation is to reduce the numerical strength of the House. Until the resignations are accepted, members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 193(3)(b). Whether in a situation such as the present, an elected government is entitled to continue despite resignations of 22 of its members has a significant bearing on the issue of confidence. But if this is right, then the governor is right that if 47 people want to withdraw support, it is the most relevant fact to be considered while deciding the floor test. Nothing beyond that. Governor does nothing beyond that. Neither the governor nor, for that matter, the court can entrench upon the power of speaker, but the pendency of proceedings before the speaker cannot be a valid basis not to have the confidence of the House in the government determined by convening of a floor test. Added to it is a factual circumstance in the present case that the speaker accept. No, that's on the facts of the case. Kindly allow me last para 81 We have highlighted above factual scenario only to emphasize that convening of a trust vote is of crucial importance to affirm fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that government owes collective responsibility to legislative assembly, and as a collective body, the legislative assembly is entitled to hold the government to account. The ultimate expression of accountability is the exercise of or the lack of confidence in the Council of Ministers. We are therefore unable to accept the submission that the holding of a trust vote would short circuit the jurisdiction of the Speaker. My Lord, rest, my Lord, may not be relevant, my Lord. Now, my Lord, last. My Lord, kindly take my Lord, propositions, my Lord. My Lord, para 7. I'll just quickly go through, my Lord. There are only 2 pages, my Lord, left. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing. Your lordships may, my lord, read them, my lord. I am not reading it, my lord, for the sake of convenience, my lord. 8. The governor, if satisfied based upon the material available, your lordships can skip that. My lord, kindly come to 10. The governor in the instant case did not recognize the split as alleged. If the governor would have recognized the split in Shiv Sena as alleged, he would have directly called Sri Eknath Shinde to take oath. There was a split. The governor merely, based on objective material before him, none of which is disputed on facts, formed an opinion as to the doubt about as to whether Sri Thackeray enjoys majority in the House, and considering the threats and violence, he should be immediately called upon to face the floor test. Lord, now this is 11 is important. Lord, the argument was that floor test could not have been ordered because this side and other independents, etc., who withdrew support from the government, they should have gone for no confidence motion. And this is a new point, my lord, which I would be urging for your lordship's consideration, not argued, my lord, so far. First of all, my lord, whether it is a floor test, which is a motion of confidence, or a no confidence motion, my lord, which is negatively worded, the result is the same. And therefore, there can never be a ground to invoke your lordship's equity jurisdiction in a 226. Floor test also, the numbers will be counted and people would decide whether I have the majority. In no confidence, numbers will be counted and members would decide whether I have the majority. But there is something more than that. Lord, please come to PDF page 40 of Convenience Compilation 3C. Lord, the provision in the Maharashtra Legislative Assembly rules regarding no confidence motion. Lord, your lordships are confronted with a situation where the governor is receiving representations that we have withdrawn support, we want to withdraw support, etc., etc. I'm not repeating. There is a threat of violence. There is in fact violence. Attacks are taking place at the houses. And now, my lord, the submission is that you should have allowed the no confidence route rather than directing a floor test. Please see, my lord, now page 40 of my lord's Convenience Compilation 3.
3C.
CC3, my lord, Convenience Compilation 3. My lord, that is part of rules of Maharashtra Legislative Assembly rules. Your lordships have said, my lord, please bear in mind that such floor test cannot brook any delay. And why is this reliance on no confidence motion? Maybe they wanted more time, which the governor prevented them from doing. Para 90, rule 95. Your lordships have that, rule 95? Yes. Well, two things I'll say at the outset and I'll read this. First,
3C, okay. 3C.
First, any member can move a no confidence motion only when House is in session. Not otherwise. House was not in session. Number two, it depends upon the discretion of the speaker whether to allow the motion to be placed or tabled or not. It's not a right. So again, I'll be dependent upon the discretion to be used by the speaker if I'm the elected representative. This is what My lord, therefore, governor says that no, you hold a session. Kindly see, my lord, Rule 95. A member who desires to move, your lordships have them. The member who desires to move for leave to make a motion expressing want of confidence in the Council of Ministers or a motion disapproving the policy of the Council of Ministers in a particular respect shall give written notice of such motion. If the motion is admitted by the speaker, leave to make the motion may be asked for. So first, he can sit for 1 week to decide whether to permit this or not. But if he admits, then the members will seek leave to make the motion for on such day not later than 2 days after it is admitted. If the assembly is in session, as the speaker may appoint, after questions and before the list of business for the day is entered upon. So when the assembly is in session, this can be done with the speaker. There is no time limit fixed. He can decide to admit it after a week. And thereafter, if the assembly is in session, the members can say 2 days. Now, my lord, further, provided that, the lordship said, my lord, the next page, provided that if the notice of such motion is received when the assembly is not in session, the leave to make the motion may be asked for on a day not later than 2 days after commencement of the session, as the speaker may appoint. So the next session may be after 15 days, after 1 month, after 5 months. We do not know. Your lordships are deciding this constitutional principle that whether the governor was right in directing summoning of the House for floor test, and they are saying that no confidence motion was the route, meaning thereby this threat, allurement, violence, etc., continues, and the governor's satisfaction that prima facie the government has lost confidence would continue without any legitimacy. My lord, borrowing your lordships, very, very, my lord, pertinent expression. After the member has asked for leave of the assembly to make the motion, the speaker shall read the motion to the assembly and request those members who are in favor. That's the procedure, my lord, how the motion would be passed or failed. So, my lord, this is no remedy in fact situation like this. Because the taste, my lord, right from the state of Rajasthan till Shivraj Singh Chauhan is, it cannot brook any delay. Last 3 points. Last page of my proposition, my lord. My lord, 12 I have already covered. 13. My lord, decision of the governor to direct floor test is not to be based on aid and advice. My lord, para 28 of my detailed submissions, I have already covered that. My lord, I have, that's what your lordships have held in Shivraj Singh Chauhan. After the decision of Shri Uddhav Thackeray not to face the floor test by tendering resignation, the only option for the governor was to call Eknath Shinde, who could prima facie satisfy the governor that he can form a stable government. Another option was, my lord, 356, which is frowned upon, and nobody, my lord, that has to be the last resort. And how, my lord, that happened, my lord, please come to, my lord, as a last submission, my lord, written, the documents which I have placed. My lord, the governor received 2 letters that now Eknath Shinde has the majority. And, my lord, another very risky argument which Mr. Sibal made, that why did the governor call Eknath Shinde to form the governor? And why not the president of the party was consulted? My lord, the governor knows only the elected leader of the house. He is not concerned with political parties. There are political parties where leader of the house is in fact the leader and president is not controlling him from somewhere else. Governor has to contact the elected leader of the legislative party. When he is shown, my lord, I'll show, my lord, those documents. There are 2 letters, my lord, I'll show that document. Because, my lord, every party has a different structure. Kindly see, my lord, the mischief in this argument. I'm saying argument, not mischief in making of the submission. My lord, mischief. I'm sorry, my lord. I thought, my lord, my.
They're relieved with your clarification.
No. It was not correctly worded, my lord. the potential mischief if this argument is not accepted. That's what I wanted to convey. Lord, every party has a different party infrastructure. For example, in some parties, the highest authority is the general secretary. There is a Politburo in Communist Party. General secretary is the highest authority. In some, my lord, there is a body, 5 people, my lord, committee or something. In some, there is a president. There may be a dispute who is the president. Governor would not enter into that. Governor would say that who is the leader of the legislative party. Governor would deal with only leader of the legislative party, and Mr. Uddhav Thackeray, who did not face the confidence and therefore he resigned, is not even a member of the Legislative Assembly. My lord, kindly see page 47, PDF 47 of the governor's compilation. My lord, this is the
PDF page? Sorry.
page 47 of governor's compilation. My lord.
Signed by 34 members. Para 2. Para 3, letter of 21/6/22 addressed by Mr. Shinde to the Deputy Speaker. And lastly,
The apprehension of MLAs is also fortified by the letter of leader of opposition,
That's in
who
the
has in
context
fact
of
provided, no, kindly further, provided links to videos where Mr. So-and-so has openly stated that dead bodies would come. And I would, my lord, earnestly urge, my lord, not to condone this. My lord, this is a threat in public platform. My lord, let us not, my lord, lessen the gravity of it. It's a very serious thing. I leave it at that. I leave it at that.
Law and order situation.
I leave it. No, my lord. It can be law and order situation also. But if that law and order situation is being created to bring pressure on the legislative process, then it's not just a law and order situation. It is one of the major consideration for the governor that yes, he seems to have lost majority and now open threats are being administered that you come in our fold or you will be sent to post-mortem. It's a threat to death. I would, my lord, earnestly request your lordship, my lord, that it cannot be taken serious, my lord, lightly by the constitutional.
But that
I leave
would
it
be a
at
ground for unseating a government. I mean, ultimately, that somebody who
I'm
makes that
sorry.
threat is subject to section 156(3), is subject
I'm
to
sorry.
an FIR. You can do what you want about that.
Kindly allow me
threat
to,
which is given.
my lord, put it differently. My lord, that's where the perception differs. If I say that because somebody is threatening, you face the floor test, then your lordships are right. But when I have the letters that we want to withdraw support and we are being threatened, then it's not that reason. That's the ground, not the reason.
We'll hear Mr. Sibyl and they have to say in rejoinder, I think.
Yes. My lord, one clarification, not on the merits of the case. I checked up. The couplet, my lord, which I started with.
This was not Barelvi.
It's by Dr. Bashir Badra. They are contemporaries.
Oh.
Their style of writing is very similar. It's likely to mislead, my lord, every reader. It's by Dr. Bashir Badra. He is no longer there, my lord. Wasim Barelvi Sahib is...
you're giving credit where it is due.
Yes, my lord. Especially when he is not. Dr. Wasim Barelvi is also, my lord, he is alive. Dr. Badra passed away recently. But contemporaries, same age group.
Thank you, Mr.
Obliged to your lordship, my lord, and sorry for, my lord, exceeding the... But
No.
your lordship...
You also asking questions, quite a few of them. Thank you, Mr. Solicitor.
Obliged to your lordship.
What I've done, my lords, I've filed a rejoinder of submissions, my lords, before your lordships.
Has it been circulated?
it was circulated, Malaj. We have hard copies, but it was circulated.
Upload हुआ है?
Where?
Upload नहीं हुआ।
But please airdrop it.
अभी कर लेना।
It's not here.
It's been circulated.
It has been circulated.
It's been circulated, Your Lordships, Malaj.
At 9:50.
In the morning itself.
Quarter
yeah.
past 9.
Yes, Malaj.
That's why it's not here.
That's correct.
Other side, the rejoinder submissions given are lengthier than my reply. Other light, you need not respond to that. It was a fun.
I have to respond to more weighty things than
For 9?
the pages of my rejoinder. Malaj, Your Lordships may just, at the moment, Malaj, not deal with this document. It will come to you. Let me just broadly tell Your Lordships, Malaj, what we have to meet and what the issues are. Malaj, I think that we seem to have been, we are somewhat innocent of the manner in which people are represented in the House and who a legislator owes his duty to. Well, as Your Lordship knows that under the 1950 Representation of People's Act, Malaj, you have a delimitation commission. And in each state, a delimitation takes place and the territorial constituencies, Malaj, are carved out. So the elections takes place with respect to those territorial constituencies in each state, and the number is already, Malaj, fixed. So, Malaj, under the Representation of People's Act, first under the Constitution, under Article 170, people are directly elected from the territorial constituencies. And, Malaj, there is a process by which, Malaj, they are elected. That process is also, Malaj, elaborately set out in the conduct of election rules. First, there's a nomination that takes place, Malaj. The nomination takes place pursuant to your party nominating you and giving you the symbol on the basis of which you go to the returning officer and say, I am the nominee of the party and this is my symbol, which represents the party. After which, Malaj, the election takes place. And when the election takes place and the votes are counted, Malaj, the returning officer then gives you a certificate saying that you have been elected from this party. A copy of that is sent to the Election Commission. It's all set out here, so Your Lordships, at the moment, I'm just broadly. A copy of that is sent to the Election Commission, and the Election Commission conveys that to the Speaker of the Assembly. What is it that I'm trying to say? The only identity of a legislator recognized in the House is that he is a member of the party. He has no other identity. Two members, 3 members, 20 members, 34 members can't have an identity outside of that. That's the basic constitutional question. Give Your Lordships an example, Malaj. Forget about 34. A small party in Goa has 5 members. 2 of them go to the Speaker, to the Governor, and say, you know, I'm not going to support this government. And those 2, Malaj, actually tilt the balance and the government can fall. So the Governor will call a floor test.
Sorry?
Will the Governor call a floor test? Forget majority, even the minority cannot topple the government, if this is the procedure in law that we have to follow. We are back to Ayaram Gayaram. Why? Because you say, now your political affiliation doesn't matter. What matters is numbers. Democracy is not about numbers. It is numbers within a constitutional framework. What the legislators, the Speaker, the Governor recognizes are political parties. And you are a member of a political party, nothing less, nothing more. You have no other identity. And I tell your lordships why I'm saying this. How are governments formed? Sarkaria Commission, remember, Maharaj? Largest single party who has a majority on the floor of the House, the governor will call him to form the government, the leader to form the government. If that's not possible, comes the second, and that's political party now. Second, pre-poll alliance of what? Of political parties. That's the second, if they form the majority. Three, post-poll coalition.
What is the first?
Single largest
Yes.
political party. Second is pre-poll alliance of what? Of political parties. Could be one, it could be two, it could be three.
Which is the third one?
Third is post-poll coalition, which is what the Uddhav government was. Post-poll coalition of political parties. And the fourth is post-poll alliance of political parties. The governor, under Article 168 of the Constitution, is not a member of the Legislative Assembly, but he is part of the legislature. He can't recognize anybody other than political parties. That is the constitutional fundamental framework within which the House functions. That's why we did away with Gayaram, Ayaram.
Lastly, the governor is not part of the.
He is part of the legislature, but not a member of the Legislative Assembly. So he only recognizes, because he is part of the legislature, the political parties, the legislature parties. That means my identity is associated with my party in the House. I have no separate identity. Otherwise, mothers, 10 from one party, 2 from another party, 3 from another party will go to the governor and make the government fall. And then my learned friend's argument, see, the governor is fully satisfied that you have lost the confidence of the House because 10, 2 and 3, along with the present dispensation, make the majority. So you back on Ayaram Gayaram days? The whole purpose of the 10th schedule is to get rid of it. Numbers in the House will not make governments fall. It is the alliance of parties in the House that will make the government fall. And that's the application of mind of the governor when he decides to ask for a trust vote. See the havoc it will cause. All you need to do is to look up numbers, and they will say, Malats, on public platforms that it is a call of conscience. Malats, we know the extent of their conscience. They'll go to the governor and say, see, we give you the numbers now. This is my letter to you. We are now the majority. This government, this chief minister has lost the confidence of the House. See the numbers. And it will be argued that, look, it's demonstrated that it doesn't have the majority and therefore hold the floor test. You see the consequences of this argument on the democratic polity of this country. That's one issue, Malas, I will deal with. I just want to point out. Number 2, even more important. which is something that I mentioned earlier also, and in detail, Malad, in my note, and which they did not comment on at all. All the council have not commented on the concept of the whip. In fact, I was really surprised when my learned colleague, Malad, Mr. Kaul, gave to your lordships a letter of Mr. Sanjay Raut. Your lordships will remember that, saying, no, actually, it is the legislative, it is the leader of the house who appoints, it is the leader of the house who appoints the whip. Well, let's just kindly have a look at that letter. It is the last page of the submission, Malad, that was. I just handed it to your lordship.
6th July 22.
Yeah, just see, it was a very interesting letter. Now, your lordship sees this. This is to the Speaker of the Lok Sabha. Lordship sees that. And 13th June 2019, which was handed over. Yes.
No. This is Baba Sahib appointing him.
That's correct.
That is Rajya Sabha.
Kindly, no, this is 1 second. This is by Eknath.
No, this is by Bala Sahib.
Lok Sabha.
Appointing Rao.
Yes, now see what is the last page at page 44. Sanjay Raut writes to Malad, the Speaker of the Lok Sabha. That's what he pointed out. Have that document?
Yes, yes.
Says, respected sir, it is to inform you that Shiv Sena Parliamentary Party has nominated Rajan Vikhare, MP, as Chief Whip in Lok Sabha in place of Bhavana Gawali with immediate effect. Signed, Sanjay Raut, leader of Shiv Sena Parliamentary Party. Correct, Malad? Now just see the previous page. Sanjay Raut is a member of the Rajya Sabha, not a member of the Lok Sabha. He is appointing the leader in the Lok Sabha. Appointment of Shiv Sena Parliamentary Party leader for both houses, Lok Sabha and Rajya Sabha. Dear sir, Shiv Sena has the strength of so much in the Lok Sabha. Previous page, Malad. Vinayak Bhaura Raut is the Shiv Sena group leader in Lok Sabha, and Sanjay Raut represents Shiv Sena as group leader in Rajya Sabha. In addition to the above, I hereby appoint Sanjay Raut, member of Rajya Sabha, as Shiv Sena Parliamentary Party leader for both the houses of Parliament, Lok Sabha, Rajya Sabha, as a facilitative measure. May I therefore request you, esteemed office, to take note of the same and communicate accordingly. And Malad, I gave to your lordships chapter and verse. Erskine May, all the authorities merge as to how it is the political party that appoints the whip in the house. Paksh Pramukh. And this whole argument was jettisoned by showing this document saying, see, Sanjay Raut is appointed. He's not even Malad, a member of the Lok Sabha. He is empowered by the party. So this whole argument that I sat in Assam, appointed Gogavale as the whip. Where does that come from in constitutional terms? 34 of you sitting in Assam in the lap of the BJP will appoint Gogavale as the whip and then come to court and say, look, we have already removed you. Under what power?
Sorry for interrupt. This may not be relevant for the.
Sir, if you don't mind, sir, sir, I mean, I really will appreciate. You people have, my colleagues have answered for 5 days. I have not uttered a word throughout. So please allow me to at least argue in my own way.
Saturday, Sunday. But appointment of whip in Rajya Sabha, Lok Sabha, it would never be over. We curtailed our arguments. In a rejoinder, my lord, appointment of whip in Lok Sabha.
Well, if you want, I can sit down and the court can decide, since you are the master of the ceremonies here. So, Malaj, because that was an argument made, Malaj, because that justifies, what they say, that justifies the fact that Gogable is the whip and he issued directions and he has to be obeyed. Malaj, till the 4th, who was the political party recognized in the assembly? Shiv Sena. That was a political party. Who was the whip, Malaj? Sunil Prabhu. So the second submission that I wish to make to your lordships is,
First and second are more or less both men. Basically saying that whips are actually appointed only by the political party.
that's right.
It's a simple point.
That's simple, very simple points. Appointed, so Malaj, the whip has to be obeyed. Sunil Prabhu had to be obeyed.
You made this point.
Yes. On 3rd, Sunil Prabhu issued a whip that you cannot vote for the BJP candidate as speaker. Whip was disobeyed. He cannot appoint himself as the leader because Ajay Chaudhary became the leader on the 21st of June itself when we removed Eknath Shinde. That removal of Eknath Shinde and appointment of Ajay Chaudhary was conveyed to the Speaker of the House. The Speaker of the House recognized it. So how could the governor call Eknath Shinde? Who is Eknath Shinde? I'm talking in constitutional terms, Malaj. Argument is Eknath Shinde was the group leader. Where was the, under which law? Which group? You can't arrogate yourself the powers of the party. Sitting in Assam, being entertained by another party, publicly saying that another party is fully supporting me, and changing the constitution of the House as if you are the political party. That's the second, which I will argue, Malaj. I won't take too long, Malaj, just so that we reduce the level of controversy. Number 3, my learned friend, my colleague, Mr. Kaul, Malaj, argued that I am the party. He says, I am the party. I am the Shiv Sena. Well, on what constitutional basis can people with 34 members say they are the Shiv Sena? Are they recognized by the Election Commission as the Shiv Sena? Shiv Sena is a registered political party with a political leadership, Malaj, intimated to the Election Commission under Section 29A of the Representation of People's Act. The moment the recognition takes place under Section 29A, that is the decision of the Election Commission, which is final. That decision was not overturned by anybody. When all this happened till the 4th of July. So, Malaj, how can Eknath Shinde's group of 34 say, I am the political party? It has no constitutional basis. And for 5 days we have heard this, Malaj. I am not saying that I have split. I am not saying that I am the faction. I am saying I am Shiv Sena. So if I say I am Shiv Sena, I am Shiv Sena in constitutional terms. Cannot be. Next point, Malaj, which is even more important. Malaj, your lordships will remember that under paragraph 3 of the 10th schedule, which was deleted later by the 91st Constitutional Amendment, the expression is that if there is a faction in the legislative party arising out of a split in the political party, and that faction represents 1/3 of the legislative party, then that will be a valid defense against a disqualification petition. What it is. So what does the expression used there? I am a faction of the legislative party, resulting from a split in the political party. Right, Manoj? Now, he says that we 34 are the political party. That's his case. He says, I'm not a faction. There's no split. But Manoj, when he goes to the Election Commission, what does paragraph 15 say? That if there are two factions of a political party who claim to be that political party, it doesn't use the word split. Then the commission will decide which is that political party. So before you, they say, I am the political party. And before the Election Commission, they say, I am a faction. Because if he is the political party, he need not go to the Election Commission. Why is he going to the Election Commission? He says there's no difference between the legislative party and the political party, which is Malaj, a mockery of the 10th schedule itself, where the whole purpose, Malaj, of differentiating was that members of the legislative party will not do acts which amount to voluntarily giving up membership of the party or vote against the whip, which will result in defection. The whole purpose of the 10th schedule is to differentiate between the legislative party and the political party. And the whole argument is there is no difference between the legislative party and the political party. I am the political party. But if you're the political party, why did you move the Election Commission? Well, let's take, for example, 3 people out of 5 belonging to the Congress party. They are a majority. They go to the governor of Goa and say, I am the political party. We're the majority. Topple this government. Numbers are stacked against, government will be toppled. They will never go to the Election Commission. Why? Because there is the Congress party outside. What will the governor do? Governor, you think, Malaj, on their logic, governor will have to call a trust vote, because the best way, Bomai says, the best way is to find out from a trust vote. Malaj, all judgments of law are contextual. Unless there's an underlying basic principle, like basic structure. Otherwise, all judgments are contextual. When your lordships, Malaj, decided on Shivraj Chauhan, the context was what? 22 resignations. Context.
And 6 were accepted.
Yes, 6 accepted. Not only that, 13th of March, governor tells him to hold to call the assembly, which is called on 14th March, and hold the trust vote on the 14th. The chief minister says, no, I adjourned it. He didn't put it in the agenda. He adjourned it to 26th March, if your lordships will remember. So he adjourns it to 26th March. Then the petitions are filed. Saying, how have you adjourned it to 26th of March? Because the governor told you, matter comes to this court, and your lordship says, look, this is the best, because all those 22 letters of resignation are with the governor. Then your lordship said another thing, which I'll read later to your lordship. Your lordship said, as far as the disqualification is concerned, who stopped you from disqualifying? That's paragraph 82 of your lordship's judgment, where your lordship said this. Nothing stopped the governor, the speaker to disqualify if he wanted to disqualify. But once people have resigned, so it was in the context of 22 resignations, context of 6 of them having been accepted on the 14th of March itself on the advice of the chief minister. Speaker accepts them. And your lordships ask the question, what's the difference between those 6 and the other 16? There's no difference. They have come, the signatures are there, they have given to the governor. What else can we do? And who stopped you from disqualifying? Well, what has Shivraj Chauhan got to do with this? This matter? There's no bearing. We're dealing with what? We're dealing with 34 people, which is a faction. They can't now say they're not a party, that they are the party, because they can't be the party. It's a faction. How does the governor recognize a faction? Under what constitutional parameters does the government say, I recognize you, and therefore I'll call a floor test? It's not a game of numbers. So if you actually hold their submissions to be correct, you're bringing back the regime of Ayagam Gayaram, because anybody can collect the numbers in the manner that they are collected nowadays, whisk them away to any other state, keep them in comfort. I don't want to use a stronger word. And then let's come back and topple the government. And you'll have no recourse. Next is even more important.
You're saying 3/4 is also a split.
Yes, exactly.
According to you, even 3/4 will be split.
That's correct. That's still a faction. That's why 3 was eliminated. You can't have sort of factions moving out, because we know how these numbers are collected. Then I remember, I showed you Kuldeep Nayyar's case, where all that was set out. More important, whereas they have only on the today in court argued that they are the party. Not a single document, right from the 21st of June, till they file the petition, even there they do not say, till the 19th of July. Whole argument is, I am the party. Where have you said ever that you are the party? Never. Not a single document. This is a mockery, Malaj, that's happening in our country. And I said, Malaj, and I repeat it, it's not about Maharashtra. It's about Meghalaya, it's about Manipur, it is about tomorrow Uttar Pradesh, it is about anything can happen anywhere if you allow this to happen. It's about our future. So, Malaj, they never say that they are the party. Even if that, your ladyship will remember that document on the 28th of June that was read. First of all, Malaj, let me disabuse you of this whole thing about violence. On the 27th, when we moved this court, they moved this court. My learned friend was there, I was not there. On 27th, Malaj, a statement was made by Mr. Kaushik, who was Mr. Chitnis, yes, saying that Mr. Chitnis, learned counsel for the state of Maharashtra, states that adequate steps have already been taken, and the state government has further ensured that no harm is caused to the lives, liberty, and property of the 39 MLAs and their families. This on the 27th, and the governor is arguing, well, on the 28th there was a danger, there'll be dead bodies, it will be post-mortem. When on 27th a statement has been made by Mr. Chitnis, who represents the Maharashtra government, under the supervision of the Supreme Court, can anybody, Malaj, say that, look, dead bodies will be sent for post-mortem? This is a 27th June order. And that was repeated again and again and again. Malaj, if I were to go to the newspaper reports and what they have said in Assam, Malaj, that your lordships are not going to enter into that. And Malaj, the unfortunate part of it, and I say unfortunate, Malaj, deliberately, the very thing that we wanted to prevent happened. When your lordships did not grant us stay, fine, no issue. But we went to the election commission, we told the election commission that, look, these are the very 39 people whose candidature as a member of the Legislative Assembly is subject to the Supreme Court. So please don't decide this matter till that is decided. No state did not mean that you decide no matter what happens. They misinterpreted that order deliberately, not the commission, but the other side. And said, no, Supreme Court has said, no, stay, you have to decide. And then what did the election commission do? On the basis of these 39, they've got the symbol. Only on the basis of these 39. So what are we here today? Today they argue, now we are the party, because you've got the symbol. So, on 27th of June, we are put in difficulty. 29th of June, we are put in difficulty. And then in September, when your lordships passed this order, they misinterpreted. 27th September. The next point, your lordships will have to consider, and I'll be very short, tomorrow, so that we can finish this quickly. Next point is, they have been saying that under the mandatory rules, 7 days notice ought to be given. Correct, How many days notice have they got now? They have not filed reply till date. 9 months? And I asked myself this question, when this court said, don't file your reply till the 12th of July, was it 7 days? Is it fair of the court, I'm sorry to say, if that is the mandatory rule, then you should have said 7 days from the date? Shorter period? 12 days, and that also in the interim. And 9 months have passed. And then Mara's argument is this is a fait accompli. See the arithmetic. Even if the 16 had been disqualified, you would still be in minority. And I think Mr. Salve was right. That's all speculation. What would have happened, what would not have happened. Maybe the others would have voted in our favor. But that's all speculation. Your lordships are not concerned about that. What the arithmetic is. And see the injustice caused to us, in this process. So they don't file a reply. Now they say, go back to the speaker. And there is no one fact which is not admitted on both sides. That they have 34, majority in the legislative party, admitted. We don't deny it. That they were sitting in Assam, they admit. That they sent that resolution throwing out Sunil Prabhu, they admit. That they appointed Gogavale, they admit. And whereas what's interesting is in that resolution that they sent, where your lordship said the only 2 prayers that are made are that Gogavale is appointed. But see the language as far as Eknath Shinde is concerned. He continues to be the leader. The word continue. But how did they realize that the word continue has to be used? Because we had removed him on 21st. And on 22nd, they dated the letter 21st and sent it to the speaker, received by the speaker on the 22nd at 11:30 a.m. So they knew that Eknath Shinde had been removed. Otherwise, they would have said that Eknath Shinde is the leader. But they said, no, Eknath Shinde continues to be the leader. And they backdated that document. So, that's not disputed. That we called a meeting on the 21st, 22nd, not disputed. We told them if you don't attend, consequences will follow, not disputed. On 24th, we had a council meeting, not disputed. They said, but nobody called the council meeting. We'll hold a parallel meeting of our own, not disputed. What is disputed? That on the 28th, the governor received these documents which have been placed before your lordships, not disputed. That he called for a floor test, not disputed. That he resigned, the chief minister, then chief minister resigned, not disputed. That he went to the governor along with Mr. Fadnavis, not disputed. That he was sworn in, not disputed. that there was a trust vote and we issued a whip, not disputed. That they voted against the whip, not disputed. What is disputed? Nothing is disputed. From the beginning to the end, the whole process is clearly political. Clearly political. And whereas I want to know, your Lordship knows about it, that a whip is appointed at the instance of the political party and conveyed to the speaker. That's conveyed to the speaker. How is the governor talking about the whip being Gogagle? He's talking about Gogagle being the whip in his communications. He's not concerned with it. That's a matter of the House.
Governor spoke of, not
Gogagle. Gogagle being the whip.
spoke of leader of the house, right?
That also. How is he?
He was the whip,
I think also leader of the House.
leader of the house, Shinde.
Yes. Now, how is he concerned with it? He is not there to appoint the leader of the House or to recognize. Yes. He says a purported appointment of Ajay Chaudhary is illegal. How is he concerned with this? See all this, the letter that he is sending to Uddhav Thackeray.
Governor's letter.
Yes. Governor is saying all this.
You're referring to para
Is it
3.
Karim?
Yes, para.
That is his letter to Uddhav Thackeray
Yes.
Ah.
Yes.
for holding the trust.
So why is he? Yes.
Trust
Correct.
vote का जो letter लिखा
Correct.
था.
And he's saying all this. How is he concerned? And if they continue to be the Shiv, I'm grateful to your Lordship when your Lordship asked, if he is the Shiv Sena, then where is the loss of confidence? There's no loss of confidence then. What he's doing is he's recognizing 34 people to be a faction. And on the basis of that recognition, then determining that there should be a trust vote. That's what he's doing. The fact of the matter is, in law, he cannot recognize. And neither Bomai, nor Shivraj Chauhan, nor any of those judgments will come in the
The
way.
solicitor argued towards the latter part. He said that what they said in their letter was that we wanted to withdraw support from the MVA government.
Yes.
So he said this in effect was therefore a withdrawal of support to the government.
Let's assume, Malaj. I will assume that against me. That can happen in any situation, Malaj. Any 2 people, 4 people, 7 people, 12 people, 30 people can withdraw support. They may be members of the legislature. That is why the whole purpose, Malaj, of the Constitution, Article 170 onwards, and to only recognize political parties, the whole purpose is that. That's why Kyoto says, Malaj, that you don't have any other identity. Integrity of the political party and the political process. That's why. I will accept all that, Malaj. That's exactly the Ayaram Gayaram test. That anybody can walk out.
The difficulty arises in an emerging situation. This is the question that's been troubling. In an emerging situation, suddenly during the process of the existence of the legislative assembly, there is this kind of a dissension. Take, for example, this very case. So what is very apparent so far as the House is concerned, 34 have come on to one side.
Right.
This doesn't definitely, there's no material that it reflects what happened outside.
That's right.
There's no doubt about that.
Yes.
But in a situation, perhaps is it possible, how does one, let us say the speaker, when such a thing is placed before him, would he also take into account or merely adjourn the case, asking the parties to go back to the election commission and get it proved?
Yes, but I was going to come to that. Malaj, let's forget this case. Let's take a case where people, I don't take for granted what that letter says on the 22nd, that the electorate is unhappy. Your Lordship knows, there's not a single instance of any of them making any statement prior to the 21st of June that anybody is unhappy. This is all their statement made, because they are now sitting in Guwahati and they know what the consequences. And they didn't go to Surat and Guwahati, on the 21st. This must have been pre-arranged, These things don't happen overnight. But be that as it may, I don't want to enter into the politics of it. But your Lordship is right, it is correct, but that these things will happen. But what is to be done? What is to be done is, if you are a faction and you go to the governor will say, I can't recognize you. You want to say you are the political party, Now forget this case. You go to the Election Commission. You say you are a faction. I am the political party. Supposing you had gone to the Election Commission and done that, and then attempted to change, no problem. First, the commission would have decided. In the meantime, the disqualification petitions would have been heard. That's the constitutional, and don't connect one with the other. Then the disqualification would have been decided. Then they wouldn't have been able to go to the commission because you're deemed to have given up membership of the party. And forget, so there may be no dispute at all, Why do you say there's a faction in the legislative party? There may be if two factions within the political party, each claiming that they are the party. Forget about disqualification. What's the procedure? Go to the Election Commission. Can the procedure ever be that you claim as a faction of the legislative party to be the political party, get recognition from the governor, topple the government, then go to the commission and say, these are the 36 or 38 members of the legislative party. We are dominant in the legislature. Now we must get the symbol. Cannot be. By any standards of constitutional law, this cannot happen.
What happens in the interregnum?
Sorry?
What happens in the interregnum?
Suppose
the speaker takes a prima facie view and says that go to the election commission and come back to me and tell me who actually is the political party.
No, the speaker will not do that, and with great respect.
Then he proceeds with 10th schedule.
No, yes, he'll proceed with it.
Then all the 34 will be disqualified.
Yes, why not?
No, I'm just asking you.
Yes, but there will be.
So therefore, that's the consequence.
Yes, there will be. Let me tell you, Lord, this is also a very other important aspect of the matter.
With the advent of 10th schedule in a situation like this, where more than 3/4 of the legislators have, let us call it not a split, let's call it a faction in terms of symbols order.
It is a faction.
Symbols order. Let us call it as 3/4
yes.
are in one group.
Yes.
Then in which case, it's an inevitable consequence that the faction which is in control of the government would have the speaker with them and would disqualify them.
Yes.
There is no other alternative according to
you. They can't be, for the reason the third paragraph has been deleted. The whole purpose of it is that you cannot have, see, they will still be disqualified for their acts for having voluntarily given up membership of the party.
It was 1/4.
Even if they are the party,
It was 1/4, Mr. Stibble. That's why I was asking them repeatedly.
1/3.
1/3,
yes.
right? We are talking of a 3/4 situation.
Doesn't matter, because 1/3 could have been 2/3 also.
Isn't there a difference between split and overwhelming majority of legislatures?
No, that's not recognized by the 10th schedule, The 10th schedule doesn't recognize it.
What does Quixote say about Quixote?
No, Kyoto doesn't say either.
About it.
Kyoto doesn't say either, but Kyoto doesn't talk
I want you to just help us on this.
I will. Tomorrow I'll help you. But just one.
This is something which we...
One last thing I just wanted to mention, that anyway, we'll do it tomorrow. It's better.
Sorry?
We'll do it tomorrow, It's better. We'll do it tomorrow.
We'll do it, give a thought.
Yes. I've now given your lordships, in the entire argument. Now it won't take very long. Obliged.
And that prima facie stand that they have argued, that also just tell us about that. Just tell us that work.
Sure. Deeply.